On Law Weekly today, we continue our assessment of how well the judiciary fared in the year 2019. We talked to a senior advocate of Nigeria, Clarke. We also have the views of some other senior lawyers on what the judiciary can do better in this new year, plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. In continuation of our assessment of the judiciary in the year 2019, today we talked to a senior advocate of Nigeria who has practiced law for over 40 years. I began by asking Chief Clarke to assess how well the judiciary fared last year.
You see, generally, under the old law, electoral law, all election matters relating to House of Assembly, House of Representatives, the Senate, and the gubernatorial elections. The final court in determining who won or who lost was determined by the Court of Appeal. Today in Nigeria, we have almost 34 divisions of the Court of Appeal. So, if cases come and they only end at the Court of Appeal, maybe 3 or 4 months, we will have dispensed with all. But during Katsina Alu's case,
that's the former Chief Justice of Nigeria,
the former CJ, and the Salami saga,
former President of the Court of Appeal,
it was the view that the Sokoto election tribunal had gotten money and bribed the panel. And if I think well, Katsina Alu now asked Salami to stop the judgment of where he had no power under the law. And Salami told him, look, I am president of the Court of Appeal. Because you are Chief Justice, you cannot
dictate to me.
So he refused. And you know what happened? They said they promoted him to the Supreme Court. He refused to go. And he just ran out his period in disgrace, which is not fair. But he now decided, because of that, to ask the House to amend the electoral law.
That's talking about Katsina Alu.
That all gubernatorial matters, all senatorial matters, all House of Representatives should all end at the Supreme Court, thereby inflicting self-injury to themselves. You can imagine. Pre-election matters also go up to the Supreme Court. Last year, I think the CJ was complaining that they had made about 268 pre-election matters. And you can see how it had harmed them. I see my young friends who are judges, who have grown, from hard work, grown old from hard work. I know they are working hard, but it's a self-inflicted injury. If they had not on their own accepted that all cases should come to them, we would not find ourselves. And what is the effect? The effect is that other matters that are relevant to the country are put at bay, because there is this feeling that all political matters must be dispensed, quickly.
Speedily, yes.
Now, another question is the tribunals. You are creating tribunals in about 36 states. You are picking judges from the different judicials of the high courts, and you are asking them for 180 days in the year to sit in the tribunal. What happens to their normal cases in their courts? You find that for those 180 days, all cases already listed for hearing in those courts cannot be heard. You are thereby dislodging the whole judicial system. My take is this, that the Constitution should be amended so that when you are creating the electoral, go and find judges who are retired judges, so that when they do this job, then they will not disturb the normal calendar of the law or other courts. Also, create a constitutional court whereby all election matters will terminate in a constitutional court, and allow judges to be appointed in that court to be judges of the Supreme Court level or Court of Appeal level.
Where are we going to find these judges from? From
retired judges? Okay. No, in the constitutional court they must be serving judges. Sorry. For the court, they must be serving judges.
So we pull out from this system that we already,
or you can appoint
more judges.
Yeah, you can appoint more judges to fill, so that all the election petitions terminate there. and only allow the Supreme Court to have jurisdiction on the presidential election. It will reduce all this hard work. I feel sorry for them. I see most of them, they have aged due to hard work. They've aged due to hard work. I pity them.
When you say constitutional court, now the court, this constitutional court, you say that we should have sitting judges of the Supreme Court level to head this constitutional court?
Where it is being done, it is an intermediate court between the Supreme Court and the Court of Appeal. That gives you the efficacy. You are now, throwing the jurisdiction. That look, you are the final court. You are not the Supreme Court,
okay, like
but you are the final court for election matters. So you elevate it a little bit above the Court of Appeal and below the Supreme Court, and you find judges, about 8 judges or 9 judges who are appointed. They will manage 2 or 3 courts.
They sit every day to make sure that this matters. And then when elections, the election season is over, what happens to the judges?
It's finished.
They go back to the regular pool?
No. They take up appeals. They take this. It may take a year, but it won't take more than 1 year. 180 days for the lower tribunal, and or maybe 6 months, and everything will be finished, and the country will not be held in hostage. But
when these judges finish deliberating on all this election matters, whether it takes a year or whatever length of time it takes, then what happens to those judges?
This thing comes in every, you see, the election problem takes over 1 year in Nigeria. Now it takes over 2 years of the system we have, and 4 years after that, a new cycle begins. So if you have constitutional judges on a permanent scale, not ad hoc scale, permanent scale, they will have many things to do. There are 36 states, 36 gubernatorial election petitions, appeals, 30 senators, 93. Nigerians have the tendency to challenge any election result.
So they sit in judgment over election results from all parts of the country?
Oh yes, as the highest court, just like the Supreme Court, for all other matters, they will sit as the Supreme Court for election matters. So
election matters first go to the normal tribunals,
yes.
Then it comes and terminates at that constitutional
directly
court. That's
from
what
the tribunal,
you're proposing.
It goes to the constitutional court.
Okay. But then, like, one of the things that you've alluded to was the fact that other cases suffer when election matters come up. Business lawyers will tell you that they suffered a lot of cases. A lot of other litigants didn't have access to justice because we pull out judges from the system. But this arrangement that you're proposing, we're still going to pull out judges at the tribunal stage because the constitutional court is only going to be an intermediate court.
I have already stated that judges in the tribunals should not be serving judges.
Okay.
They should be judges that have retired, who still have the strength. They retire at the age of 65. I am 82 now, and I still, run the courts. So a judge who is 65, who has retired, or 70, will gladly take up such judge.
Do we have a lot of such judges around to sit and manage all election petition tribunals?
Do you know how many judges retire from courts in Nigeria every year? Over 30 every year. And if you look at a range of 5 years, that's almost 100 judges who will be available
to sit
to
in
run the
election
36
tribunals.
3 times 36, that is less than 100. We have the men around.
This constitutional court that you've proposed, who has the responsibility for driving it and making sure that it comes into existence?
Look, like the Court of Appeal has the president of the Court of Appeal. Administratively, he or she takes over the control of the judges, asks them, to perform certain duties. So the same thing, the law creating the Constitutional Court will make provision for a president of the court and other judges, and they follow the same system that is going on in the Court of Appeal.
But who should kickstart the process? The Chief Justice of Nigeria?
No. It's a constitutional amendment.
Okay.
So that a president of that court will have been appointed, and he takes over the administrative duties, and they appoint other judges, just like Court of Appeal.
Apart from election petition matters, I want us to talk about corruption cases and how well the judiciary fared with regards to corruption cases. You were one of those who felt that the federal government deserved credit for taking the former Chief Justice of Nigeria, Walter Onogen, before the tribunal, that they knew what they were doing. You said so in one of our interviews. But But you still maintain that view, especially against the background of what some have called selective prosecution.
I've always had that statement, selective judgment, selective whatever.
Prosecution.
And you will find that this statement comes from the opposition party. They feel that it's only the opposition, PDP, that have been, dragged by EFCC to court, and that none of the government APC have been dragged to court. Even though I will not want to disagree with that, but this is a political matter. The Yoruba say, "Oda." Anybody who steals and is caught, it is not for him to say, "I am not the only corrupt man." After all, Lagbaja is corrupt. This one is corrupt. No, it's no defense. At least a system now exists where corruption. Can you imagine a system, a constitution that allows a governor, after 8 years, bearing this excellency tag, now walks from that governorship seat into prison? That system has to be looked into. Why should our governors, after reigning for 8 years, be dragged to the courts and into the prison? Something is wrong. But we need to fight it.
Shouldn't the way to fight it be an attitudinal change on the part of our leaders? Shouldn't they be decent enough to keep their hands away from public coffers?
Look, if you show that if you steal under a system, you are not going scot-free, and you start from the opposition, when the opposition comes to power, those who are doing it now will know that they will be the next. So it will urge you to, canvass for votes very well, do well, so that when you come back to power, you will start the same thing you think Buhari is doing now. But I don't blame Buhari. He has to start somewhere. And we are happy now. Okay, look at Ojikalu. Was it APC Buhari who took him to court? Not him. PDP took him to court, and he has been in court for almost 16 years. So selective or no selective, the important thing that we are fighting corruption in a way. The politics of which I agree may exist, but it would be a foolish head of a party to ask that his deputy be taken to court for corruption. If he says that, he's eroding his popular base. So it's a very difficult thing to do. If they even canvass it, it will be difficult.
But can we really continue like that? Because what you're essentially saying is that any politician in power cannot prosecute people from his party.
Not that he cannot prosecute. They've done it. Buhari has done it. What about Maina?
But they are few and far between.
Your selection range by the PDP is that they should go and take Tinubu. They should go and take Amechi.
If they are found to be corrupt,
no,
why not?
No. This is not, game playing. This thing. This is politics. A politician will fight for his survival. If a politician uses his hand to attack the base of his party, then he knows he's out of power.
Let me round up with the issue of disobedience to court orders. A lot of people fault the federal government with the issue of disobedience of court orders. Thankfully, towards the end of the year, the government released Showore, Dasuki, and El Zazaki is still in detention against so many court orders asking for his release. But can the judiciary still continue to fold its arms while the federal government willfully disobeys its orders? What do you think?
Do you know how many court orders are made in a year by the courts? Thousands. If you pick 3 to say government is doing Mon Jankara or Wayo, you have forgotten that this is not up to 1% of the judgments of the court. Now, when you look at the 3 cases you have mentioned, Showore's case was based on treasonable grounds, and SSS had the sole organization that look into all these things. And if the court gives, a bail, they take him for another thing. They are being smart about it. And there are tough lawyers around who fight for them. Today they have been released. We should thank God that we have a government that works under pressure by the masses. Look at Dasuki. The same thing. He frees in one court, they take him to another court. All the steps are legal steps. But Oye and Tonje, now they have also kowtowed. They have allowed public opinion to the shite matter. The federal government says, look, It's a state matter for Kaduna State. It's not our responsibility. So which are other things that they have not done that you think they can
But the length of time it took to obey those court orders.
Look, this is politics. Their cases have political connotation.
So when it concerns political cases,
Oh,
a
yes.
different standard applies.
Definitely, because that is politics. But they do it according to the law. But there's nothing wrong in it, because Nigeria has a society of people who can fight for freedom.